basic, and you could say, hey, if you just read the document, it speaks for itself. But I think practically speaking, a lot of buyers don't realize the implication of actually signing a purchase agreement. They think, hey, I'm going to sign this purchase agreement, then I can have an inspection, and then I'll find out if there's problems, and if I don't like it, I'll walk away. But in the real world, the issue comes up with this definition of what is a defect under the purchase agreement. And when a buyer signs that purchase agreement, they should be advised, and they should understand that if this gets accepted, you're buying this house for the most part. I mean, that should be your starting point, is that you need to be very committed to the possibility of moving forward on this transaction to closing and buying this house, but for some very limited situations. And the principal situation that comes up is when the inspection reports reveal a defect. And this is where you get into sort of competing interests on all sides, because you have the seller, you have the buyer, and now you're inserting the inspector into the process. And inspectors, of course, want to cover themselves. So they're going to be, as generally speaking, as thorough as possible and put all kinds of stuff into this 90-page document. And then that scares the bejesus out of a lot of buyers when they see all of these things and are trying to wade through what does that mean, especially buyers who may not have a lot of, this may be their first home, they may be people that don't know anything about construction or home maintenance, and they see all of these issues, and now we have an issue. And the MIBOR purchase agreement is that clause concerning defects it's sort of like a lawyer's dream clause in terms of creating business. And I don't know of a good way around it. I mean, there's no magic solution for it unless somebody came up with these really rigid standards that everyone applies to. But what it says, in effect, is that if the buyer reasonably believes that that a defect has been discovered with the home that was not previously disclosed by the seller, then they can elect to terminate if the seller won't agree to fix it. And it kind of tries to give a little bit of a description about what constitutes a defect under Indiana law. But until you get that, if you have a dispute between the seller and the buyer over whether something constitutes a defect that allows the buyer to terminate or to require the seller to fix it, then the only person that's going to make that ultimate decision is a judge. And now you're talking about a year's worth of litigation and a bunch of attorney's fees and a lot of headache. So who wants that? No one does. But that's the reality of the situation. And in the meantime, you've got a seller that's trying to sell their home, you've got a buyer that's looking for a home, and you've got earnest money sitting in a vault at the title company that's not going anywhere until that dispute gets resolved. And so the reason I bring all of those points up is that a buyer may think, oh, well, if there's going to be a defect, it says that's whether I reasonably believe that there's a defect or not, so I get to make that decision. But unless the seller agrees to cut you loose and to release that earnest money, it's just going to sit there until the situation gets resolved or settled. And some buyers may be able to just move on and put down earnest money on the next house that they find if they decide to move along. Some buyers are, that's all the money they have for an earnest money deposit, and now they're kind of locked into this situation. So I think it's a really serious discussion that needs to be had with each buyer, and that they should, to some degree, be aware that, like, once they sign that purchase agreement, if it gets accepted, they need to be, all intents and purposes, ready to buy that house.
Yeah, that's so helpful. Thank you. Okay, and then changing subjects, can you talk about like seller's responsibility after the house is closed, the buyers are living in it, something goes wrong? Are the sellers obligated to do anything about that?
Yeah, so the basic premise that you start with is that once the closing occurs, the that's it. You've there's a doctrine under the law called the merger doctrine, and what that says is once the closing occurs, all sort of conditions and agreements that were between the buyer and seller merge into the title and basically go away. And so that's the basic starting premise. The MIBOR purchase agreement has a clause written into it. I believe it's on the last page in the additional provisions section. I forget which paragraph number. That says, that includes a contractual provision that says that any terms and conditions of the purchase agreement, which would include inspection responses that get accepted by both parties and addendums and that type of thing, it would cover all of that, shall survive closing. And so if you have a contractual provision like that that says that these obligations will survive closing, then they do survive closing. And so I think from a broker perspective, you just want to make sure that if you are, and this kind of goes towards just general good practice principles anyway, make sure if it's something that your buyer or seller are really serious about, make sure it is in the purchase agreement, it's in writing, it's written well, such that anyone who reads it, can understand what it means, that it's written thoroughly. And in that case, if the seller doesn't do what they're supposed to do, then they're still obligated to do it even post-closing. That can present some challenges when you have a seller that moves to Bermuda or something like that after the sale, which I've seen happen. Sellers can disappear sometimes. So I think the buyer's best practice is to do re-inspections prior to closing, make sure everything is dealt with before you go sit down at that table, because once the closing occurs, it's really hard to claw people back to the table to get them to deal with things, especially if you have someone that just moves far away and chooses to ignore any further obligations. From your guys' perspective, you may sometimes find yourself where you're dealing with a non-MIBOR purchase agreement. I see that come up time to time, where maybe you step in at the middle of a transaction and some people have already started going down the road with sort of a self-created purchase agreement or something that the lawyers have created. And especially on commercial transactions, usually those contracts are not form contracts. Those contracts may not include a post-closing clause, and you'll want to maybe think about that again. If it's something that you really want to keep someone on the hook for, it needs to be in the written document.
That's great. Thanks, Josh. We've had a couple questions come in. This one's from Natalie on earnest money disputes. Josh, can you share insight into any defects you've seen that might be worthy of getting EM returned or not worthy of getting their earnest money returned?
It's so hard to answer on saying that that's kind of a lawyer's dream clause, because the purchase agreement has that language of sort of some basic examples, things that affect the habitability and safety of the home and those types of things. And so it really just comes down, obviously the seller and the buyer can have very different feelings about whether something constitutes a significant defect or not. A seller's thinking, look, that's been there for the last 15 years, it's never caused me any problems. I don't know why you're making such a big deal out of it. And then a buyer who's investing all this money in a home that they don't know very well and is wanting to get the most bang for their buck, and not step into some significant issues, is going to think everything is a potential defect. What does it mean for something to affect the habitability or safety or value of the home? Well, to a buyer, everything affects the value. So it's just impossible to provide a bright line rule about that. And that's why, I'm telling you guys, it's a huge part of any lawyer that does real estate law. We're dealing with that stuff all day long. And it's just because there's no easy solution for that. And the end result, if the buyer and seller can't come to some resolution, it's going to be a stalemate, and they're going to have to start getting lawyers involved. And now, you're paying people hundreds of dollars an hour on both ends to try to get this thing resolved. And one other point I wanted to bring up about earnest money that I see is that if the case results in litigation where the parties are suing each other over whether or not the purchase agreement needs to go forward because of a defect issue, and they're the buyer's trying to get their earnest money back, the title company will start, they'll get their attorney involved, and now you've got the title company attorney billing time. And the title company will say at the end of the case, when it gets settled or when a court issues a decision, the title company will say, hey, well, we've got $2,000 in attorney's fees into this. We want to withhold that from the earnest money, or somebody owes us that money. And so now you're deducting title company fees out of that earnest money, or it's got to come from somewhere, and that further complicates things, obviously.
Yikes! Sounds terrible.
Yeah. Again, it's why I really stress, from a buyer's perspective, don't think that you're going to get to just pull the plug really easily, because sometimes that's not going to happen, and there's no easy solution.
Yeah, that's great. Another question from Joel. How would the EM situation, or getting earnest money return situation, apply differently to an as-is agreement? What's different about that?
I would think that on an as-is contract, so it depends on how the contract is written. So a lot of times in the sort of general standard in commercial transactions is that the property is being sold as is, but the buyer has a period of time to conduct their inspections and do their due diligence, and they can get out for any reason whatsoever. So any reason that they want to back out of the deal, they can get out and get their earnest money back. And that's a very common way that commercial transactions are written. In the residential context, I think it just depends on what the contract says, that if the buyer has a period of time to do their due diligence to find out what's going on with the property, but there's an agreement that the seller is not going to fix anything, I feel like the buyer should be able to get out for any reason. I think the best way a contract can be drafted, across the board, is that the buyer can get out for any reason whatsoever. Let's sign a contract. Let's give the buyer a limited period of time to get in and take a look around, and then they can get out if they want to. And that just evaporates that whole issue of people arguing over this defect matter. That's not how the industry works. That's not how the agreements have been drafted. And so, that's the situation that everyone puts themselves in. So it all comes down to whether or not the buyer has the absolute right to terminate for any reason or not. If they don't, and there's some sort of catch, like they have to find a defect or something, you're going to be in the same situation.
Yeah, thanks. Another question from Billy. How would you advise a buyer who wants to make changes to the standard verbiage of a purchase agreement?
That's a good question. And that's something I see a lot of times. A lot of issues that I've seen in cases, frankly, are bad drafting by brokers. And I see, I know a lot of people on this forum, and, obviously, Leslie, I get to see, how her practice unfolds on a daily basis. Things move so quickly that a lot of times brokers are just scratching things into agreements. I see agreements not getting signed by people end up in a dispute and they send me the purchase agreement documents with the inspection responses and addendums, and then some of them don't have signatures on them, and some of them are signed by only one of the sellers or one of the buyers, or signed in, the property is owned by an LLC and the purchase agreement signed by just a person. There's no mention of the LLC. So things move at a breakneck speed. I think you just have to make sure you are going to get creative and draft unique provisions or alter the terms of the standard form. You need to draft it well. You need to write it clearly. You need to write it thoroughly. And if you feel that it's sort of getting into testy territory and beyond your ability to write something thoroughly and competently, then you may want to refer them to have an attorney get involved. I think that's probably unnecessary to get an attorney involved for something like that most of the time, but just make sure that you're drafting something very clearly and well written.
That's great. Thanks, Josh. Okay, next question for me. Listing broker due diligence about the property being sold. Can you talk a little bit about that?
Yeah, this one came up. This is almost like one of those situations that I guess in your guys' context, it would be like a broker school exam question or something like that, or this would be the type of question that would come up on on the bar exam. This really far out situation that I had happen recently. But especially with the way the market gets, and how it's been the last couple of years, with a lot of investors getting involved in distant markets, people in California getting involved in Indianapolis real estate market, you end up with a lot of people who own properties who've never even seen it. And the property will change hands multiple times, with all of which each one of those parties never having even visited the property. And so I had a case recently where it was exactly that situation. This hotshot California, real estate investor owned this property in Indianapolis for a number of years. It was a duplex, and they go to sell the property, and my buyers, who were also investors, they write a purchase agreement, and before they write the purchase agreement, they do a bunch of research on the property, and they see that there are 2 duplexes on this same parcel of property. And so they write the purchase agreement. Hey, we'll buy it for this amount. Seller says, great. Everybody signs. And then on the day of the inspection, my clients say, hey, we need to get access to this second building. Dead silence on the from the seller's broker. Hey, we really need, how do we get the key to the second building? We want to conduct an inspection. No response. They just do an inspection on the first building. And then a couple of days later, they get a letter from a lawyer saying, hey, some issues come up. We didn't realize there's a second building on the property, so that changes the terms of the agreement. We're canceling the purchase agreement. So my clients are like, no, we're buying this property as we've agreed. And it was a situation where the seller had no idea that there was a complete separate duplex on the same parcel of real estate. The seller's broker also didn't know, but if you go to the assessor's website and you pull the property card, clear as day, there's both of the properties are there, they're referenced, they're sketched, and on the broker's MyBoard listing, which I don't look at those very often, so this case was interesting. I got to sort of go behind the curtain, so to speak, and look and see what you guys see all the time. But there's a separate tab, for I forget what it's called now, but like the parcel information or something, and it had all of that MyBoard, all of the assessor's data there. So they had just not done their due diligence to understand what was being sold. And once you looked at the property, if you just took the time to go look at it, you would clearly see that they even referenced that the property had alley access. And the only way that the property could have alley access is if between the street and the alley, there were two houses. And so that was an interesting situation. We ended up getting it settled after quite a while, but that was a very interesting case. And so it really just brought up to me that people get lackadaisical. Things are moving so quickly. You get excited. You have this, person that wants to hire you to sell their property. And so you just jump out the gate and start doing your thing. I think you need to slow down, and you need to understand the property that you're going to be listing, because in the end, the sad part is it would really affect, the brokers that get involved in that transaction, especially the seller's broker who invests time and money to market the property, and then suddenly it's tied up in litigation, or there's some huge problem, and you may not get your commission, or you're going to have to really fight for it. So that was one example, and I think some other contexts where if you're a listing broker, you need to be careful and maybe slow down a little bit. One would be like inherited property. So if your client is someone that just recently inherited the property but's never lived there, they don't know much about it, you probably need to, number one, look at the physical property itself, but then also, make sure all the legal process has been gone through to make sure that title has gone from the estate, or from the deceased person to the person that you're dealing with. Are there siblings involved? So are there other people that are now legal owners of this property that I need to be getting into the conversation? I'm just talking to this one person, but is everyone on board with selling the property? And there was one other that came to mind. So there were inherited property, out-of-state owners. The other would be sellers that may have a lot of financial problems. I had a case recently where it sort of involved two of these issues. There was three siblings that inherited a property from their mother. Once the title gets transferred, everything gets worked out, they go to sell the property, they sign a purchase agreement with the buyer, and then when the title search gets done, it turns out one of the siblings had like 6 judgments against him. And so that threw a huge wrench into we could not get those issues resolved because we were trying to contact the judgment creditors. Some of them were really old, and unless you can get releases from those creditors or get those claims settled, the title company's not going to close. And so, again, we had a selling broker who did all of the work that they were required to do to get this property sold and under contract, and then at the end of the day, there's no closing. So that case is now involved in litigation, and the broker is seeking their commission. They're suing for their commission. The siblings are all fighting with each other about whose fault it is that this situation was created. So I guess practically speaking, one thing that a listing broker could do is you need to have a really detailed conversation with your seller. Try to find out if there's any red flags with credit issues, potential judgments out there. And then if any of you don't know, at least in Indiana now, we have something called My Case. It's a website that you can go to, and pretty much all of the counties throughout Indiana are on My Case now. And you can type someone's name in, and it will pull up any lawsuits that person's been involved in for a very, very long time, and it goes back a very long distance. So it's not like it's not going to catch everything, or maybe will not give you all the information that you need, but it's a good starting point. It's free, it's easy, you can get on. And if you see, hey, my sellers, had a lawsuit last year, something filed against them, I need to look into that a little bit further before I put a whole bunch of time and effort into this case or into this listing. We may want to get those things cleared up beforehand.
That's super helpful. Thanks, Josh. I'm curious for the first case that you mentioned with the double duplex situation. Was the second duplex just sitting there vacant, or were there tenants in it? How does that work?
Yeah, so it turns out that there were people living there, and I don't know exactly what the story was there because I was representing the buyers, and we ended up getting the case settled where my clients were just got money. They agreed to back out and in exchange for some cash. So, but there were people living in that other property, and the listing broker, I believe, went and knocked on the door and was like, "Hey, who are you guys? Who are you paying rent to?" Um, and I don't know what the answer was, but I know that that was something that they had to figure out.
That is so wild. Oh
It
my
was
God.
it was very bizarre.
Yeah,
I know Leslie and Natalie and that team heard me talk about that situation.
yeah, that's wild. Okay, so obviously through that situation, we've already talked or touched on investors a little bit, but I know you and I talking beforehand, you had a little more to say on what we should know about working with investors. So can you touch on that a little more?
Yeah, I'm trying to remember what some of those issues were. I think, oh, okay. So with investor clients, they're a special breed of clients for sure. Um, and talk about fly by the seat of your pants. These there's just a huge gap of savviness, with that type of client. Some people really, know what they're doing and do things really well, and some people, it's their first foray and they're super hyped and they, it's sort of the Wild West. Um, so a lot of times when you're dealing with investor clients, you're going to be dealing with legal entities. So they'll create an LLC or a corporation to own the property. And again, I think the first step in that process, if they have a legal entity, make sure that it's up to date, that it's properly registered with the Secretary of State of whatever state it's incorporated in. I mean, a lot of times people give me the name of an LLC that they're working under, that the property's owned by, and you go look it up, and it was administratively dissolved 5 years ago because they created it and then never did any follow up. So make sure that that stuff is all up to date and being managed properly. And then if the property is owned by an LLC or a corporation, or if the people are buying the property under the name of an LLC or corporation, then all of the contract documents need to be in the name of that legal entity. So if you have John Smith, and he's got Property Bros LLC, then he needs to sign every legal document, Property Bros LLC, John Smith, comma, member, or something along those lines. So many times you have, just John Smith will sign all the documents and be like, oh no, this is my LLC owns the property, or I'm buying it under the LLC. Well, that's not the case if all the documents are in that person's personal name. So make sure all of that corporate formality is all followed very closely throughout the contract documents. And then the second issue is transferring the properties. So these people, these investor clients, for one reason or another, are just constantly putting properties in different entity names. They'll buy it under one entity name and then immediately after closing deed it over to some other entity or something like that. And the thing that they need to understand that we see happen a lot of times is if you buy the property under one name, whether it's an individual or a legal entity, you're going to have title. Most of the time you're getting title insurance. Will be an insured closing, and so that title policy ensures that transfer. Well, then if they immediately transfer that property to another entity, either a person or another corporate entity, that insurance doesn't transfer. So now you've got an uninsured title for that new buyer, and people just don't even think about that. But it could be an implication if something comes up and they say, oh, well, we need to submit a title claim. The title company to say, well, who are you? You were not our insured, and so there's no coverage. I think those are kind of the main issues. Make sure you know who you're dealing with, make sure the corporate formalities are followed, and the title insurance implication.
Yeah, that's great, Josh. Can you speak a little bit about how agents should be communicating to their clients, what they can say, maybe not say, how they can keep themselves out of litigation to the best of their ability?
Yeah, so a lot of times when a transaction blows up, you know, the individuals involved, will get an attorney, and then they want to sue everyone. They want to, you know, if it's a buyer, they want to sue the property inspector for not properly disclosing something. They want to sue the seller. They want to sue the seller's agent because the seller's agent's the one that told them that, oh yeah, the buyer had or the seller had this thing fixed. So they just want to go in and sue everyone. And there's a lot of bad lawyers out there who maybe don't know what they're doing in a real estate context, or they just don't think through these things, and they'll follow their client's wish, or maybe they'll encourage their client to sue everyone, trying to get at the broker's E&O coverage or something like that. Even if the broker had no liability or responsibility whatsoever, it happens all the time. And so what I would tell brokers is that you are your client's agent. You're not selling the property. It's not your house. You are just an arm of your client, essentially. So I would say, like, and it seems like more and more clients are wanting their brokers to take on more and more responsibility. And of course, you're eager to please and you want to get a good reputation. So you really try to go out of your way to do as much as possible for your clients, whether it's the seller or the buyer. But when you do that, you're sort of inserting yourself into more and more aspects of the transaction. And so what I see a lot of times, especially with distant sellers or buyers, is that the broker is the only one with feet on the ground where the property is located. And so they're taking on all this responsibility to maybe find contractors, schedule contractors, get things signed and that type of thing, verify that work's been done, all of those types of things. And now you're just kind of inserting yourself more and more in different aspects here, and your name is all over the documents. Sometimes I see contractors like when they issue an invoice for the work, they send it to the broker with the broker's name on it and everything, so it almost looks like that contractual relationship was between the broker and the contractor instead of the client and the contractor. And so one recent case I had was a distant seller who was in Florida. The property was here in Indiana. The buyer was buying this condominium, and the seller was supposed to put in an entire new HVAC system. And so the seller, said, hey, whatever, agent, just deal with it. So the seller's agent hires this HVAC company and schedules them. They come in and do the work, and then she tells the buyer and the buyer's broker, yeah, the work's been done. It's all good. They said it's all fixed. Closing happens, and the work was just terrible, and the system didn't even function. And so the buyer sued the seller and the seller's broker and was arguing, well, the seller's broker is the one that hired this company. They told me that all this stuff was completely fixed, etc. And we had to explain to that buyer, look, the agent was just acting on behalf of the seller. It's the seller's contractual duty. But all of that is sort of a long way of saying, I think that when you do these things for your clients, you refer contractors, or you maybe even schedule contractors, and maybe a lot of times you're going to be the one talking to the contractor 100% of the time, not the client, or at least most of the time. Make it very clear in all of your emails, and if it's going to be text messages, so be it. But just make sure that you're being very clear that you're acting on behalf of your client. You know, you can't say it too many times. Just put it everywhere. You know, and if the contractor issues an invoice and it has your name on it, you need to say, no, you need to tell them to issue a new invoice. The client's the one that hired you. The client's the one that's paying for your work. The client's, you know, the customer here. You need to invoice directly to them and not put my name on it. So just be very clear with everyone when you're doing those things that you are acting on behalf of your client and not the one on the front line. And I think another situation that I see a lot of times is that, you know, you guys have so many connections in the industry to contractors and that type of thing. You get used to dealing with the same people all the time. And so you may have a client that needs to have something done. And you say, hey, call. So, you know, oh, you got to call this person. Or I've even seen situations with brokers that have such a stable of contractors that it almost seems like those are their contractors. And so they'll tell their client, oh yeah, no worries, we'll get this stuff done. And the broker just, you know, arranges all that work, and the client has nothing to do with hiring these contractors or dealing with any of the work getting done or anything. And when it turns out that there's problems, then the client's saying, well, you know, I hired you to do this stuff. You're the one that arranged all these contractors and did this stuff. You know, I had nothing to do with it. And almost like the broker is now a general contractor. And I mean, you can cross that line if you take that far enough. That can turn out to be true. And so just be careful with that. You guys are helping your clients buy and sell the property. Everything outside of that, you're just performing a service as your client's agent, and you just need to make sure that that's very clear to all people involved.
That's great. We just had a question come in from Diane, from Natalie. She said, does this mean an agent should not order an inspection for a client as well?
I think that you can order the inspection, just making sure that's very clear, as I think, you know, the inspecting companies know this generally, but it's very clear that the inspection is being ordered on behalf of the client, not the broker, and that it's got the client's name on it. I think, you know, another thing that you can always do is just give your clients a range of options of people to choose from. If you're making referrals, say here's 3 people, you call them and figure out who you like the best and make the arrangements and negotiate the price. But I'm not, you know, because sometimes they'll go, well, my broker told me to use this person. And, you know, if you can help stay out of that, then that could be helpful to you. Give them a range of people to choose from, let them make that decision.
That's great. Guys, I have one more question for Josh, but I wanted to kind of open the floor to you guys. You can drop it in the chat, or you can feel free to unmute yourself if you want to ask him any specific questions. I'm going to pause for just a second.
Hey, Josh, it's Meg. Can you talk a little bit about whose responsibility it is to prove that repairs have been done? I mean, is it the seller's responsibility to demonstrate they've been done right, or is it on the buyer
to? I would say the legal obligation for the seller is to just do the repair. And if it's supposed to be done by a certain time frame, that's part of their obligation as well. So if it's supposed to be fixed before closing, then if they say, look, we did the repair and it's done, then technically they've sort of met their duty. Verifying that it's been done, it would then be up to the buyer to, you know, make that decision. And yeah, so you know, I think that the seller's obligation is to just get the thing done, and then the verification process would be up to the buyer whether it's done to the correct standard or not, or if it was done timely or not. With regard to the investment investor clients, or this could be any client that doesn't have any personal knowledge of the property, whether they've never lived there, they've never seen it, would be disclosure issues I forgot to bring up. So with the seller's disclosure form, now there's these legal duties to disclose certain things. A lot of times with investor clients, they may say, well, we don't know anything about the property because we've never been there, or if it's an out-of-state owner that's never been there, or someone that inherited the property. But if they've owned the property for a period of time, they may have had a management company that's been operating it for them. That management company is their agent, and the management company's knowledge of the property, any problems, if there's been a flood or this, that, or the other, that knowledge is the owner's knowledge. So I think that if you have investor clients and there's been a management company involved, with regard to disclosure issues, you're going to want to have a conversation with the management company as well, because they are the agent of the owner, and so their knowledge is the owner's knowledge.
That's great. Anyone else have anything? Okay. Oh, Ryan?
Hey, Joshua. Thanks for doing this. I missed part of what you said in regards to LLCs when clients are signing on behalf of their LLC. Did you say that they need to sign their name, parentheses, member, or whatever their role is at the LLC? I didn't catch that.
Yeah, so if it's John Smith, I think the example was Property Bros LLC, they should sign John Smith, comma, member, Property Bros LLC.
Awesome, thanks.
Yeah. And I think like on something else I see on purchase agreements a lot is that, up at the top of the first page of the form, where it lists the buyer name will be one name, but then the signature is a different name. So it'll be maybe the LLC is up at the top, but then the signature at the bottom just is the individual's signature. Or I've seen it, the flip-flop, the individual writes their name at the top as the buyer, but then they sign as an LLC. I mean, that should be consistent as well.
Josh, my last question for you. I've never worked with a lawyer before, but I'm curious, like, we as agents, if we happen to be in a situation where our clients end up using you or any lawyer, what are like best practices for like how we can make your job easier, how we can work best with you?
Create good documents. I'm shocked how many times I mentioned this earlier, I get what I kind of call the purchase agreement packet, which is the purchase agreement with all inspection responses and addendums. And the documents aren't all signed by all required parties. I mean, there's signatures missing, there's dates missing, the scan is all screwed up, so you can't even hardly read the document. And I think, man, how did you guys get this far down the line with these documents where you can't even read the counteroffer, but everybody signed it? And I have a case right now where the counteroffer is completely illegible. I mean, you can kind of see the signatures, but you can't read what the terms are. And when the seller's agent sent the counteroffer to the buyer's agent, he even said, like, hey, sorry, you can't really read this, the scan got screwed up, but it's pretty straightforward. And they all just signed it and moved along. So, missing documents in the purchase agreement packet. I mean, it just blows my mind that you'll have this transaction going along and the lawyer isn't getting involved until way down the road when things have already gone wrong. And I think, well, how did you guys even get to this point to begin with if you don't have documents that are completely signed? So that is one of the biggest issues that I see, are the documents just not being managed properly, handwritten in clauses that don't make any sense, that you can't figure out what the duty and obligation is. I mean, so try to write those as clearly and as possible so that anyone that reads it understands what obligation is being created. Then the other thing, the other thing is when I have to litigate a case, it's always very, very fact sensitive. And the more that things are documented, the better it is for everyone, unless you're the person that did something wrong. So many times, I'll get, I say, okay, there's this big dispute about who knows what, and so much of the key issues were just in conversations and that type of thing. So I would say create documentation as much as possible. Email is the best format because they're easy to share, they're easy to print. Of course, text messages are so big now, but trying to get people to give me good copies of text messages is like, it makes me want to scream, because people will take screenshots of their text messages and then they're like, oh yeah, I'm giving you everything, and I get this big pile of papers and you can't tell where the conversation begins or ends, and texts are getting cut off at the bottom of the screen and they don't make sure that it's on the next. They're just cumbersome to deal with. So I would say as much as possible, transact in emails. If you have a verbal conversation, follow it up with a confirming email. Hey, it was great talking to you today. Here's what we discussed, and here's what you said you would do, and here's what I said I would do. And if they don't respond and say, hey, that's not what we talked about, well, then that's kind of a good record of that's true. That is what you guys talked about and what everyone said that they would do. So the more you can sort of organize the transaction in written communications throughout the process is very, very, very helpful.
Josh, we've had one more question come through on the chat. Can you just briefly clarify the reasoning behind not having agent's name on contractor invoices? What's the importance of that?
The issue there is that I'm not saying that automatically creates some sort of legal duty by the agent in any respect, but what I'm saying is it creates a piece of paper with your name on it that gives someone something to latch onto and argue about, and it creates an issue where there doesn't need to be one. So if you want to go out there and insert yourself in the middle of as much of every transaction as possible as a part of serving your clients, that's good. And I mean, well, that's your decision. I'm just telling you that that's how you end up in litigation crosshairs sometimes, because the more duties you assume and the more you kind of are in the middle of those transactions, the higher the chance that a disgruntled buyer or seller is going to say, hey, that was your screw up, not mine. And so the absolute safest thing that you can do, and again, I'm not saying that you guys have to take this as a hard line rule, I'm just saying it's a risk you need to understand. The safest thing you can do is to stay out of all of that and just direct your client and sort of give them recommendations or give them options and let them make those decisions, let them make those communications. That's not always going to be possible. You may have to go a little bit further sometimes, or may feel like it's worth it to you to do that. And that just, as you go down that road, you could be creating some problems.
Thanks, Josh. It looks like Wade would like to jump on and ask the question. Wade, you're muted.
Morning, everyone. Morning, Josh. I've asked this question a couple of times to some agents on our team, and there doesn't seem to be like a really strong answer. If you have an addendum attached to a purchase agreement, and the purchase agreement in your mind is fully contingent on the addendum being signed, and you might be using the addendum because you don't want a lender to see it, because it might involve work that might be getting done, say, right up until closing, but you've got a pretty fair understanding of what needs to be done, say maybe a backyard remodel or something needs to be removed or added. If the PA in your mind is contingent on the addendum being signed, but the addendum never gets signed, how can you prove it? Or how would that nullify the signed purchase agreement? Because, you know, in your mind, these two things are together, but without the addendum being attached to it or not being signed, you still have this signed purchase agreement floating out in space. What is the best way to make sure that those two things are tied together? But if you specifically don't want a lender getting involved.
So are you saying that the purchase agreement has closed? And what I mean by that term is like, the way I refer to closing a purchase agreement is where you kind of have the people have had a meeting of the minds and the agreement's been signed and accepted by everyone. Are you saying that that's already occurred? So you have a binding purchase agreement?
No, say you've picked up the phone, you've called the other agent. I'm on the buy side representing my client. And you're like, hey, this house is great, but the backyard's a mess, and we need it regraded and it's strawed and seeded. But you don't want to put it in the purchase agreement itself because the lender isn't going to sign off until these things are done and maybe your client's on a timeline or the seller's on a timeline. So you just talk with the other agent, you say, hey, we'll just throw this in addendum, everyone will sign it and it'll be great. You know, kind of as an afterthought maybe. You've sent out the signed PA, they've accepted it. It's in your mind, and it might even be in their mind, fully contingent on also the signed addendum. But say the addendum never gets signed, or they refuse, or they drag their feet or something, but the purchase agreement was always contingent on this thing being done, and now it might not have been done. You know, how do you make them sign the addendum first? I mean, how does it work?
Yeah, so that's kind of just a basic issue of contract construction. And so the basic premises is, you know, with the purchase agreement has a clause in it that says that, you know, essentially, to paraphrase, you know, the written agreement is the party's only agreement. And any oral or verbal representations that are not in the written signed agreement are not binding on anyone. So if you have a contract, I mean, that's general kind of a, you know, that's going to be the rule of law in that situation. You've got a written contract that says what their understandings are. And if there's some outside understanding or conversation happening that's not reduced to writing and signed by both parties, then it's not going to be enforceable.
What if it's on an addendum, but the addendum doesn't get signed by the other party?
It's just until it gets signed and signed by everyone, it's just a verbal discussion that does not become part of the contract. So if it's something that one of the parties wants enforced legally, you can't play games like, you know, kind of have these side agreements that aren't being formalized. You got to put it in writing and it's got to be signed. Yeah.
Josh, one other question that has come through. How common is it to sue for performance? And do lawsuits go often, or do lawsuits go beyond earnest money? Often go beyond earnest money. Let's just stick with how common is it to sue for performance?
Yeah, I think I understand that question. So a lawsuit on a real estate transaction is going to involve either, you know, it's either going to be a seller claim or a buyer claim. I mean, of course, sometimes they both have claims against each other, but a seller claim is going to be for, you know, if a buyer backs out inappropriately, they're going to sue them for breach of the purchase agreement. And their first source of damages is going to be they want to get that earnest money. And sometimes the seller just is happy stopping there. Hey, I want that earnest money and then I'm going to move on. And sometimes they say, look, you know, this buyer held this property hostage for 6 months or 7 months or whatever, where we lost all this market time and we paid all these carrying costs, insurance, utilities, paying to have the grass mowed, just all of these expenses all that time. We want, and the earnest money doesn't cover all that. We want that as well. Plus, you know, once we relisted the property, we had to sell it for $30,000 less. because we couldn't find any other good buyers, so you've got to pay that difference. And so that's typically what a seller, a motivated seller that wants to get blood, those are what their claims are going to be for. Courts will, generally speaking, and I'm saying this is like a 99.5% of the time, a court is not going to enforce specific performance against a buyer. Unless you can prove that the buyer has a big pile of cash in their bank account that's sufficient to pay the entire purchase price, a court's not going to force a buyer to buy the property because, first of all, the seller can be made whole by damages. And second of all, most times, the buyers are getting mortgages, and the court can't force a mortgage company to lend the money. So it's just not going to happen. From the buyer perspective, a buyer can sue for specific performance, and often that's what their claims are for. If the seller tries to back out, they say, no, look, you've got to sell us this property, or you got to at least reimburse us for our inspection costs and title commitment costs and whatever other fees and expenses we had in investigating the property and preparing to buy it. I would say on the residential side, litigation is so expensive. I mean, lawyers are so expensive, and the process is so drawn out and long. Most people don't have the stamina or the financial wherewithal to, really fund litigating a case. So after everyone gets all hyped up and draws their line in the sand, most of those cases get settled with the parties splitting their earnest money in some way. So, when people call me, and you'll hear, if any of you that I've already spoken with about issues, or if anyone calls me in the future, you'll see that I really stress parties, before you start paying hourly fees to lawyers. Like, I'm telling you, I've handled hundreds of these cases. It's rarely is it going to go all the way to trial. Someone's going to get tired, and get fatigued before the end, and it's going to get, they're going to get forced into settling, or some other thing's going to happen. Find a way to resolve it on the front end, and get out and move along. It's just rarely worth it in the residential context to, go down the litigation path. Sometimes it's unavoidable. Settling it and resolving it takes two to tango. You can't, if you have an unreasonable person on one side, then, both parties are going to just not really have much option. But that should be the first effort, is to find a way out of the dispute early in the process.
That's lovely. Thank you so much, Josh. We have loved having you, and you've been super helpful. So thank you.
Yeah, no problem. Good to see a lot of familiar faces and names on here.
Yeah, totally. Guys, remember, no training tomorrow. I'll see you again on Monday. So have a good one, everyone.